5, 4, 3, 2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Good morning, gentlemen, and welcome to the Court of Appeals. I appreciate you participating in this Zoom argument, and based upon the weather, having a Zoom argument seems like the best thing to do under the circumstances. So we appreciate you participating. In just a moment, we're going to begin the oral argument, and of course, both of you being experienced practitioners understand the rules and the procedure we follow. And we will utilize that procedure just as if we were in the courtroom today. Each side will get 15 minutes to make its oral argument. Obviously, if you're the appellant and you've reserved rebuttal time with Mr. Hivner, you're entitled to that rebuttal time as well. Before we start, I want to introduce the panel. We have Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. I will say, if we experience any technical difficulties, what we'll probably do is pause and try to figure out what's going on, but don't get too upset about it. We'll work through it. We managed to do that last time in the last argument, and we'll do it with this argument as well if that comes to being. Mr. Hivner, anything we need to take up before you call the case?
No, Your Honor.
All right, you may call the case.
Jennifer Clarke et al. Versus City of Franklin.
We will hear from the appellant.
Good morning. Thank you for having us. My name is Ben Gastel from Brandstetter, Strange and Jennings on behalf of the appellants. We're here asking the court to reverse certain decisions made by the Williamson County Chancery Court. Specifically, we ask the court to reverse the trial court's denial of the monetary damages claim filed by 8 homeowners and award them the monetary damages that they incurred as a result of the city's unlawful and ultra-virus. Second, we also ask that the court reverse the trial court's decision not award attorney's fees for class counsel's work in securing the important and meaningful injunctive relief on behalf of the class of homeowners at issue here. This case arises from the city of Franklin placing unlawful liens on the homes located in 5 different subdivisions in the city of Franklin, and it extended municipal sewer service to those 5 neighborhoods. The appellants are here and as the class representatives, and they're asking this court to ensure that the city of Franklin, and not the homeowners like the plaintiffs and the class members, bear the costs of the city's unlawful and ultra-virus conduct.
Mr. Gastel, hold on just a second. Mr. Hivner, we seem to be having a little difficulty hearing Mr. Gastel.
Yes, I believe that may be associated with his computer, and it seems like as long as he's staying close to the computer, it comes through fine. But if we want to try, or we can have him call in like we did last time as well.
Let's let him try. If you will, Mr. Gastel, stay close to the computer so we can hear what you're saying, and if problems develop, we'll let you call in, okay?
Thank you, and I apologize for the computer difficulty.
No, it's not a problem. We just want to be sure and hear what you've got to say.
So chapter
Go ahead.
3 of Title 7 of the Tennessee Code is what is at issue in this case. It provides the means and the authority by which the city can file liens against homeowners for these types of sewer service expansions. This case arose because the city of Franklin did not follow TCA 733-314 when it filed liens against all 188 homes in the full amount of the special assessment, as opposed to what that statute requires, which is the lien attaches each year when the city is required to do its annual improvement assessments. it's undisputed in this case that the city filed liens in the full amount of the special assessment. And it's also undisputed that under the statute, the city is required on an annual basis to update the amount that each property owner owes. So, for example, if, to make the math easy, the total amount of the assessment to a given homeowner was $1,000, and it was given 20 years to pay that off. Its annual lien interest that the city of Franklin had would have just been $50. But the lien that the city of Franklin filed at the Register of Deeds office was in the full amount of that initial $1,000. Even though each year when the city is required to update that amount, that initial $1,000 may change depending on that homeowner's proportional amount of the total project costs. The trial court certified this as a class action, which is not an issue on this appeal. It did grant summary judgment to the certified class, where it held that the liens filed with the Register of Deeds were unlawful, null, and void in an ultra vires act of the city of Franklin. Notwithstanding the fact, the trial court ultimately denied the 8 class members who filed monetary damages claims, monetary damages relief, holding that the monetary damages that these homeowners sought was not caused by the liens filed by the city at the Register of Deeds office. And then
Mr. Gastel, I've got a question for you about your damages issue. In your brief, you state that the parties agreed to submit the issue of damages to the trial court on the papers submitted. What papers are you referring to?
The parties briefed the 8 damages awards, and that the proof that was offered was the claim forms and supplemental documentation that each homeowner provided. All homeowners provided, except for one, Miss Rand, the Rand claim, provided supplemental documentation either from their realtor or their financial institution that they were working with, that the lien, that is the language in all of that documentation, was the reason for either the refinance being denied or for the need to pay off the full amount of the lien as shown at the Register of Deeds prior to consummating a real estate transaction.
So you're saying that the trial judge based his decision then solely upon those documents?
Yes, and the city of Franklin provided, they also went out and got some supplemental documents with some subpoenas that they also provided in the record. And that was the record that the trial judge determined to deny the monetary relief, claiming that the damages that these people suffered really stem from decisions either by the realtor or the financial institution that they were working with their refinancing. We submit that the documents from the realtor or the financial institution make it very clear, and it's unmistakable, and I would submit not refuted, that the lien was the cause of the damage. For example, the Clarkes were denied a refinance, and on the denial letter, it is stated that the reason why was insufficient funds to close that transaction. The Clarkes then obtained a supplemental letter from Pinnacle Bank, which was the financial institution that they were working with, that said specifically the insufficient funds to close was, quote, the money required to pay off the city of Franklin lien at or before closing. That was the the unrefuted claim from the Pinnacle Bank as to why they denied the refinance. And so the Clarks made a monetary damages claim for the difference that they would have been able to, the interest that they would have saved between the time of the denial of their refinance to the time that the court ordered the liens to be removed. And that amount ultimately worked out to be a little over $7,000. That claim is indicative of many other claims submitted, where people are also seeking the transaction costs associated with refinances, where they were forced by their financial institution to refinance because of the lien that the city of Franklin filed at the Register of Deeds office. Again, I can go through the list. The Browns monetary damages claim, once again, is denied because, or their financial transaction was denied because, quote, the lien needed to be satisfied prior to our loan closing.
Let me ask you, at what point did the city of Franklin decide to allow homeowners to not pay the full amount of what was assessed? Was it after they filed the lien or before?
It was before. They always permitted the homeowners to pay off the lien over a period of 20 years. That
Do
was,
they have to agree to do that, Mr. Gastel, under the statute?
the city of Franklin had the discretion to do it that way, yes, under the statute. But what they did not have the statute to do is, once they made that decision to allow payment over a 20-year period, to say that they have a lien interest in the full amount of that initial assessment. I think that's pretty clear under 733-314. If I may move now to kind of the other interesting issue raised by this case, and I believe it's an issue of first impression in this case, in this state, is whether or not the state will adopt the common benefit exception to the American rule in class actions involving ultra vires conduct, where the class is able to obtain meaningful and important injunctive relief. And thereby, there's not a class fund in which you might be able to pay your attorneys. We ask that that doctrine be adopted for three primary reasons. First, it's a necessary and important to safeguard our system of government, which requires the judiciary to act in order to undo when the other two branches of government act beyond their authority. But as this court is aware, the judiciary can only be called upon to act when a lawsuit is filed. And in cases like this, these cases on an individual basis are simply not economically viable. Rejecting the doctrine here would have the effect of insulating from private redress an entire category of governmental actions that require injunctive relief to large groups of people, because homeowners like those that were affected here would not be able to find competent counsel to redress the wrongs done when governmental actors act outside the bounds of their authority. Second, this type of litigation should be allowed to allow these homeowners to make a make-whole remedy. They should be put back in the position that they were in had the city of Franklin not undertaken this unlawful conduct. The only way that this can be done is if they are fully compensated, including for attorney's fees, in pursuing this litigation. I see that I'm out of time.
Thank you. Thank you. You've still got your rebuttal time. We'll hear from the appellee.
Good morning, everyone. Bill Squires, and I'm the Assistant City Attorney for the City of Franklin of the Williamson County and Nashville Bars. I'm here for the City of Franklin. As Mr. Gastel mentioned, he gave a pretty good underlay of what the case was about. The city's position here is that the trial court essentially got this right, though we do disagree with one finding of the trial court, and that relates to the nature of the liens themselves. So the city is asking the trial court, or asking this court, to uphold the trial court on all issues except for the legality of the liens. I want to address one particular thing that Mr. Gastel said that I think gets to the heart of the case. And I Judge Armstrong's question was, when did the city determine that a citizen could pay the lien over time? I think the critical question is, was that part of the resolution or ordinance that established the assessment in question? And that answer is no. And as Mr. Gastel correctly said, the statutory framework at issue here grants the city permission to allow an assessment to be paid over a longer period of time, several years, however long a city wants to do that, and grants permission to allow a citizen to pay monthly if they choose to do so. That's not mandatory. And here what the city did to try and lessen the burden on some of the citizens involved was offer that option to the taxpayers that were involved, the citizens. So when they passed the resolution and ordinance, the Board of Mayor and Aldermen said, you can do this if you want to, but as Judge Armstrong was alluding to, you're not required to do so. If you want to pay the entire assessment amount outright, you can. Theoretically, it's due immediately. The assessment was for a specific dollar amount. As Mr. Gastel mentioned with the Clarks, it was about $7,000 and some change. Nothing about the statutory framework involved here suggests that a city is required to do that, or if they make that option available, that a citizen is required to do that. So that's key, because the statutory framework at issue here is designed to allow a city to recoup the costs of the improvements. Here, what had happened was these particular homeowners, their septic systems had failed. These properties had been annexed into the city sometime before. Septic system had failed. City needed to run sewer to them. This statutory framework allows the city to do that and provides a means by which to recoup its costs from those benefited properties. Now, the statutory framework allows the city to recoup 100% of its costs. It's the way it's described in the statutes, it's either 75%, or if the resolutions and ordinances contain certain language, then it becomes 100%. The city can recoup all of its costs. And these costs were a little bit high. So the Board of Mayor and Aldermen, trying to do to lessen burden on the citizens involved, gave them time. You know, you can pay this outright if you want. If you need time, you can take time. If you need to pay monthly, you can do that. The idea was for it to be flexible for those citizens involved. Now, in looking at that, our position is that in evaluating the liens, no disrespect to the trial court at all. I think the world of Judge Martin. But having said that, we think maybe he got this a little wrong. You know, there's some confusion, I guess, over the notion of an annual improvement assessment and the special assessment related to the improvements, and even just the underlying notion of what the indebtedness to the property owner actually was. But the statutes are clear about some things. The assessment amount that the property owner owes is defined in 733-301, TCA 733-301, where it defines the assessment amount. And the assessment amount is that which is required to pay the costs of the improvement. And that is to say, the full costs of the improvement. The way you determine what a property owner owes is by aggregating all of the property value of the benefited properties and determining a pro rata share of what each one is in that aggregate. So that number worked out to, for Mrs. Clarke and the Clarks, around $7,300. There's nothing in the statute that talks about or describes that a particular division should take place in terms of the indebtedness if a property owner exercises that option and it's been made available to pay over a longer period of time. In other words, the indebtedness itself, the encumbrance on the property, doesn't change if the amount is paid out over some span of time. Now, it is true that there is a time fixed for assessments and for levying the assessments. That's in, as Mr. Gastel mentioned, TCA 733-314. And it talks about the time for doing the annual assessment is around tax time when you do municipal property taxes. And the assessment becomes due at that same time. There's nothing in that particular statute either, though, that says when you do that, that if a person has elected to pay over a span of time, or they haven't paid everything off yet, but they're not delinquent, or they're paying monthly, whatever that happens to be, there's nothing in that statute that says the indebtedness itself is somehow divided or chopped up into sections. We think that's where the trial court went wrong. There's a portion of the trial court's order where the trial court specifically found that the city did not have a lien in the full amount of the assessment. It found that the city had a lien in the amount due each year, whatever that amount happens to be. That seems to miss the mark to us. The reality is that the way this framework is constructed, the city is entitled to recoup 100% of its costs, which is to say, when the assessment is first made, it's for 100% of whatever the property owner owes. If you owe, in Ms. Clarke's case, $7,300, that's what the assessment is. When you do it annually, you look at year two in this instance is going to be that amount minus whatever they've paid on it. If they've paid it off, it's zero. If they've paid it monthly, it may be some other amount. But the statute also allows you to recalculate, or allows the city to recalculate additional properties that have come online that become benefited properties, to recalculate retirement of bonds if those affect the dollar amounts, and to also recalculate for any change in that pro rata distribution. So if a property owner went from, say, 10% of the aggregate property value and they became 15%, at the annual improvement assessment time, you can recalculate what they owe. But there's nothing in the statutory framework that suggests that because someone is exercising that option to pay over time or pay monthly, the actual indebtedness or the indebtedness against the property, what's owed to the city, changes in any regard. And in that sense, the lien, what we're really talking about here is the dollar amount listed on the notice of lien itself. The plaintiffs have not challenged the assessment, the special assessment for the sewer improvements, and they're really not challenged the actual the notion that there is a lien. What we're really talking about here is what dollar amount is accurate to put on the notice of lien. And in that regard, we think the trial court really kind of missed the mark. It is a little confusing, to be sure. The statutes could be worded a little better. It does allow for those options of paying a little bit longer period of time. But even the title of that section, 733.314, includes something, time for payment. I forget the exact title, but it includes time for payment. It's really talking about mechanically, when do you determine that and when do they pay? So we're asking
Let me ask you, Mr. Squires, if a homeowner pays the full amount of the assessment and then later other property comes online and that would reduce their pro rata share, how do you handle that overpayment by that one homeowner that paid the full amount?
Thank you for that question. We would have to look at that if it happened that way. The reality is the statute, some of what is challenging about the statute to work with, that framework, is that it's trying to be all things to all people. So it doesn't dictate a response in that kind of scenario. As to what theoretically might happen, I couldn't say. We would have to look at it if that occurred.
Okay.
Unfortunately,
Mr. Squires, it is a possibility that that could occur, correct?
yes, in this scenario, yes, Judge, because the property owners could pay over such a long span of time that in year 5 or year 10, another property might come online that affects how things go. Now, I will say, part of what's happening is that in the boots on the ground scenario, what's really happening is that the property owners are paying down the total assessment amount. So it's shrinking as time goes on, and their debt amount is also shrinking as time goes on. So while the statute doesn't dictate what you would do in that scenario, we would certainly look at that if it were to happen. Obviously, that's something to look at. But yes, Judge, it does. That is a theoretical possibility that after you calculated later, the calculation might shift a little bit, and that could take place. But again, those challenges aside, none of that changes what the trial court was thinking about in terms of dividing that amount over several years or months or whatever it happens to be. The statute allows a property owner to pay all at once, divided in 2 years, divided in 3 years. In this scenario, up to 10 or up to 20 years if they wanted to take that long, but they were not required to do so. So the reality is the indebtedness is the special assessment amount. The statute is clear. That's the costs of the improvement. So what should have gone on the lien was the actual indebtedness that runs against the property. Now, realistically, year 2, that amount is a new lien would be filed that shows a smaller amount because the property owner has paid down on it. So again, the liens would shrink as it goes down, But the purpose of the statute is to give the city priority to recoup those costs. If you have a lien that doesn't include the totality of those costs, that priority is lost.
Let me ask you, is there an allegation in this case that the city failed to reduce the amount of the lien based on payments made by homeowners?
There is not, Judge, no.
Okay.
There is not. So I don't want to lose too much time, but I do want to move on to the issue of damages. As Mr. Gastel mentioned, there's some question about what the appellants are claiming caused the damage. The documents submitted by the city showed that it was not the notice of lien, the actual notice of lien that was recorded, that caused the damage. Ms. Clarke is a great example. In this situation, in this scenario, you could actually take the notice of lien out of the equation entirely, and Ms. Clarke probably would have gotten the same result from her lender. Where the issue came from Ms. Clarke was in her title insurance policy. It requires satisfaction of liens, and this is a quote, and lien claims where no notice appears of record. It also includes satisfaction of liens, encumbrances, or claims thereof, which are not shown by the public record. So taking this chronologically, the city determined the special assessment amount to be $7,300. Regardless of what might go on a notice of lien document, that's the encumbrance on the property. That is the pro rata share of cost to that property owner for the sewer improvements. So even if the city had not filed the notice of lien, we're back to that idea of indebtedness. Ms. Clarke and these property owners simply owed that dollar amount. That's what was determined. And it became clear in the deposition. Ms. Clarke was asked that question, was the damage caused by the notice of lien? Was that what caused the issue? And Ms. Clarke answered and said, no, it was rather the lien itself. And by distinguishing between the lien and the notice of lien, we're really talking about what was owed versus what showed on that piece of paper that was recorded with the Register of Deeds. And what Ms. Clarke was getting at was the lien, the indebtedness, is what caused the problem. Similarly, Ms. Brown, Philip and Terry Brown, they had the same issue. Their loan agreement required them to pay all taxes, assessments, named them specifically, charges, fines attributable to the property which can attain priority. By statute, the city's lien attains priority. So as you review the claims, you'll see that all of them, the banks and the title companies simply didn't want an assessment against the property sitting out there. They wanted that satisfied. I know that I'm short on time, so I don't want to go too much further on that. We do think the trial court got that right. On attorney's fees, we think the trial court got that right as well. Tennessee follows the American rule. You need a contract or a statutory provision. That was not present here. There's also an issue related to sovereign immunity. It's in our brief. And in this scenario, the Colonial Pipeline case is very instructive. Litigants are allowed to proceed against government entities as long as they're not reaching its treasury or funds or property. In terms of the substantial or common benefit doctrine, we would point out that's strongly disfavored in Tennessee. And some cases have looked at that. Most instructive is House v. Estate of Edmondson, where the Supreme Court said if it talks about the common fund doctrine, but the substantial benefit doctrine is an offshoot of that. And in that case, the Supreme Court said, if the underlying cause of action doesn't allow for attorney's fees, it shouldn't hear either. We think the trial court got that right, and we're asking this court to uphold the finding of the court on damages and attorney's fees.
All right, thank you for your argument. Mr. Gastel, you have 3 minutes in rebuttal, I believe.
Let me just, I want to begin by taking this concept that the notice of the lien and the lien is somehow different. In this situation, that is a distinction without a difference. I will quote the language from the Clarke's lien that was filed at the Register of Deeds. It says, quote, as authorized by Tennessee Code Annotated 733-314, a lien in the amount of $7,606.01 and second only to the liens of the state, county, and municipality for taxes and any other prior special assessment is imposed and established on the following property and it lists the property. It then closes, quote, "The lien shall be released upon satisfaction of the entire amount and shall run with the land." There's no distinction here between the notice of lien and the lien. The lien is very clear that they filed that they have a lien interest in the full amount of the special assessment. But if you go to that very statutory provision that they quote in the lien, it says, quote, set TCA 733-314 says, quote, "The lien shall attach to each lot or parcel of benefit of property at the time the annual improvement assessment is made." At the time of the annual assessment. Mr. Squires, I believe, admitted that the city of Franklin has to update these liens each year around tax time. They do that because each homeowner's amount that they owe annually is adjusted based on what happened on the taxes with regard to their proportional share of the total cost. And that's why the liens are illegal here, is because under the statute itself, it says that these liens do not attach to this property until each annual assessment is made. But the liens on their face do not say that. The liens on their face say that they have a lien interest in the entire amount. And when you cloud title like that, outside the powers dictated by the Tennessee legislature that the city of Franklin had in this instance, problems are going to arise for homeowners who want to refinance or sell. And that's exactly what happened here. And again, if you look at the documentation submitted by these homeowners from their financials, from their financial institutions and or their realtor, they all say that the problem is the lien, not the assessment, but the lien. And so maybe in an alternative universe, we could argue something else caused these people this monetary damage, but that's not the world that we live in with the notices of liens actually filed. I see that I'm out of time. I very much appreciate the court's accommodation and time.
All right, gentlemen, thank you. We appreciate your argument, and we will again review your brief and all the transcripts and the entire record and attempt to get you an opinion at the earliest time possible. We thank you for participating by Zoom, and Mr. Hibner, if there's nothing else, you may recess court to the call of the docket for the next case this afternoon.
This honorable court is now in recess until 3 p.m.
Thank you.
Thank you, gentlemen.